My name is Anita Lampel. I want to welcome you all. I know many of you, but some of you not as well as others. So a pleasure to see you. Thank you for joining us for the last night of Hanukkah. Hag Sameach. Um, I um, I am going to turn it over to Melissa Goemann to introduce herself. Then she's going to turn it back to me for me to say just a few more words about what I'm going to talk about. And then we're going to get into discussing this very important issue. Melissa?
Great, thank you, Anita, and welcome everybody. Chag Sameach. Just wanted to, for those who don't know me, my name is Melissa Goemann. My pronouns are she, her, and I just wanted to give you a little of my background in terms of youth justice. I've been doing advocacy in the youth justice arena for about 20 years now. The last 10 years or so, I've been with the National Juvenile Justice Network, which is a national organization comprised of state advocacy groups across the country that all work on youth justice reform. And we do work specifically in Maryland as one of the states that we work on. And then prior to that, I had worked at the ACLU of Maryland as the legislative director. So that's just a little of my background. And Anita, if you want to tell folks a little of your background.
Sure. Hi. So I have a PhD in psychology. My emphasis was specifically on cognitive developmental psychology, and I subsequently went into areas involving clinical work and the link between clinical assessments and the legal system. And I spent my entire career pretty much in those different areas. So adolescents, kids in the court system is something that I am very familiar with. I'll be speaking a little later on very briefly on adolescent development. I promise you there will be no quiz after this. So Melissa, let us have an introduction, please, to what we're going to talk about.
All right, so we're going to be talking about youth justice today and focused on a particular bill called the Yes Act. So I'm going to share my screen to show a PowerPoint, but we have a pretty small group. Feel free to put questions in the chat, and maybe Anita, Carol, anybody, if I don't see it, let me know there's a question, or use the little hand thing to raise your hands, and I'm happy to, entertain questions. You don't have to wait till it's all over if there's something that confuses you or just have a question about. So, all right, let me share my screen here. Okay. So this presentation is Childhood at Risk, what the Yes Act is. I need to make my screen a little smaller there so I can see this. Okay. So this is a campaign that we're working on with JUFJ, or Jews United for Justice. If you're not familiar with JUFJ, just ask me, Anita, Carol, Jeff. We're happy to tell you more. But we work on advancing economic, racial, and social justice in Maryland and DC. And we do that by educating and mobilizing our local Jewish communities like you all. And we focus on issue-based campaigns that make real, immediate, and concrete improvements in people's lives. And Youth Justice, or the Yes Act, is one of our campaigns this year. And through the campaigns, we help develop our leadership base and shift the consciousness of our community and alter the relations of power. With all our campaigns, we work with partners that are led and made up of impacted people to build that collective power and undo systemic racism and inequity. Okay, one sec, guys. I'm having trouble getting the screen to move. There we go. So I think this went too far now. Okay. All right. The Jewish values that are reflected in this issue of auto charging are tzedek, or justice. We have from Rashi, the world was created with both justice and mercy. The world only exists because of the breath of children, and from Truah, that children are sacred. So at JUFJ, we organize around our core principles, and we work on making systemic change in our region by organizing through geographic jurisdictions. So, for example, we have a Montgomery County leadership team. We build the power of our field and invest in our relationships with our coalition partners. So this all helps to strengthen the skills of our volunteer leaders and to strengthen JUFJ as an institution. A lot of people ask, why are we organizing locally? As I'm sure you all know, our federal government is pretty dysfunctional right now, and so it can be hard to move change at the federal level. But local change is a real way that we can make a difference and we can expand the boundaries of what's possible. Also, the time and money and the people needed to make local change is much more achievable than what you would need at the federal level. So the local wins are important because they do then set the stage for the larger wins. So for example, after we won minimum wage and earned sick leave in Montgomery County, the success of those wins made it possible to then win that issue at the statewide level and become a model for other states. And hopefully other states will adopt this. And if enough states have wins with higher wage and sick leave, then it makes that federal change more achievable. So all our work, as I said, is done in coalition with other partners. And this slide shows, just some of the many partners we work with. I'm sure you recognize a few of them, like ACLU of Maryland. Young People for Progress is a grassroots organization here in Montgomery County we work with a lot. Out for Justice is a statewide criminal justice grassroots organization. So these partnerships allow us to share civic and moral values with others and to amplify the messages from people who are most materially affected by unjust policies. And JUFJ volunteers often attend these coalition meetings or meetings of partner groups and represent JUFJ in strategizing and in building those trusting relationships. These are just some of our bigger past wins in Maryland. So some of you might be familiar with these campaigns, especially last year, the 2022, the Time to Care Act, which I know a lot of folks worked on. So now I'm going to start to focus on this bill that we're going to talk mainly about tonight. So to understand what it is, I want to go into a little of what auto charging is. So in Maryland, as unfortunately in many states, children, meaning minors under the age of 18, usually are tried in juvenile court. That's what it's set up for. But there are mechanisms by which young children can be charged as if they were adults in adult court, tried in adult court, and locked up in adult jails and prisons. Now, one of the mechanisms for doing that in Maryland is auto charging. And that means that for certain offenses, and in Maryland there are 33 charges, that for those offenses, children are just automatically tried as adults. So there's no decision made by a judge. If you're charged by the prosecutor with, XYZ offense, you will automatically be tried in an adult court. So Maryland sends more young people to adult court based on offense type per capita than any other state except Alabama. You can see we're in terrific company there. Of these young people, 81%, so the vast majority, charged in adult court in Maryland are Black. and Black youth are more likely to be sent to adult court and to receive longer sentences than their white counterparts for similar offenses. When you charge kids as adults, there are many, many negative consequences. We have just a few here. There's an increase that a greater likelihood they'll be experiencing physical violence while they're locked up, sexual violence, isolation, and the loss of access to education and health benefits. So I'm going to turn it over to Anita now to talk a little about adolescent development, and that plays into why it's such a bad thing to put kids in adult court.
Thank you, Melissa. So we're talking about 14-year-olds. My granddaughter just had her bat mitzvah. She's 13, she's 5'7", but she's only 13. She is not 23, despite her efforts to make her dad think she is. So adolescence means growth, especially in that vital prefrontal cortex, which is the area that serves higher cognitive functions like behavior control, planning, and assessing risk. This area is not done maturing until you reach your early 20s, and that is the point that is now considered by neurologists and psychiatrists and psychologists as, in fact, the endpoint of adolescence. The reorganization that happens in your prefrontal cortex is associated with profound emotional and cognitive changes in executive function, which are those processes that control thought and behavior and allow for the flexible adaptation to new and complex situations. It also is the area where your socio-affective abilities, such as interpersonal perspective and empathy, lie, and so that is also the area that's being impacted by this surge in growth. Teens, as a result of all of these changes, very generally, teens end up focusing much more on social engagement with peers, and acceptance is a critical issue for them. Now, compared to children and to adults, teens are much more motivated by the anticipation of reward and much less motivated by the anticipation of negative consequences. So when an adolescent is with other kids, his or her own age, and when there is the prospect of a reward in mind, the probability is that the anticipation of that reward is going to outweigh rational decision-making. Overall, teen brains respond differently to stress than adult brains. Stressful life experiences appear to actually alter the development of emotion-focused regions such as the amygdala and the hippocampus and the prefrontal cortex. This means that there's much greater susceptibility in adolescence to disorders like anxiety and depression, or to more serious disorders such as schizophrenia, bipolar disorder, and eating disorders. Add to this that most teens don't get enough sleep, and as a result of not getting enough sleep, their melatonin levels are off. And add to this hormones that are also impacting brain development. So a teen's brain is substantially different than an adult brain in its ability to make decisions based on understanding risk, and they are much more susceptible to stressors. Now, I want you to try to imagine the stress of solitary confinement, which is what happens to teens. When their brain is geared to social interaction, this can lead to a substantial increase in depression or anxiety or other forms of significant emotional dysregulation. That these emotions can permanently impact this young person's brain. And there's physical illness, which increases, so all of this increases the likelihood of recidivism. Imagine the stress of being placed with older men and all that implies for your physical and psychological and pro-social development. It's frankly just inhuman. Now, let me finish with a few notes on the misperception of Black children. And I am not going to talk about the misperception of teenage Black children, which is horrific. I'm going to talk about the misperception of very young children, pre-kindergarten, kindergarten, and first graders. When prospective teachers were asked to identify the emotion of Black and white child actors, they over-identified anger in Black children, especially girls, when no anger was present. So these child actors had been told to portray a feeling. They were portraying that feeling, and it was significantly over-identified as anger. Preschool teachers saw Black children as misbehaving more than white children in a laboratory setting, when trained observers saw no difference in behavior. By kindergarten, white teachers perceived more conflict between themselves and Black boys than any other group, and teachers disciplined Black students more harshly. When given a so-called student file with the name suggesting the child was Black, teachers were more likely to see the misbehavior as part of a pattern and think about suspension, compared to the identical file given to teachers with a name that was more linked to white. So imagine if this is what is happening to kids who are in preschool, kindergarten, and first grade. Just imagine what is happening to them in terms of stress and their ability to go through school by the time they get to middle school and high school. Thank you very much. I'm going to turn it back to Melissa.
Thank you, Anita. That was really helpful. I'm having some issues with my tech, but I'm gonna see if this, now it won't move forward again. So hold on a sec, folks. I'm gonna stop my screen share. I just need to send my slides to Carol. So talk amongst yourself and then we'll continue on in a second. All right, so we should get that going again in a minute. But what I'm going to talk about next is what happens when a child is charged as a juvenile versus being charged as an adult. So the process is quite different. And again, there are these 33 charges for which a young person in Maryland could be automatically charged as an adult. So the way that would look is that if a police officer stops a young person, depending on what they think they'll be charged with, that young person would then automatically start out in either the juvenile system. The officer would make that decision with input from the state's attorney, the state meaning the prosecutor. So then they would, go to one of two paths, either the juvenile system or the adult system, again, depending what that charge is. Next, what would happen is that the young person would, sorry, I'm trying to make sure I stay with my presentation here.
I haven't gotten it yet, Melissa.
Oh, okay. Well, let me see if I can show this again. Let's see if I have better luck then. Okay. All right. Okay, so here the next process is that the youth is taken to the police station if they're in the juvenile system, and the officer would have to get authorization from the Department of Juvenile Services to have them detained, assuming that they felt they needed to be locked up. Whereas if they were an adult, they would most likely be taken to the police station and interrogated, and then taken to a commissioner who would set bail based on what they were charged with. So if you're charged as a juvenile, then you're sent to a juvenile detention center, which is set up to, confine young people. And if you are being charged as an adult, you're sent to an adult jail where there are other actual adults. The next day, you would go to a detention hearing for a judge to determine, if you should stay locked up or be released. And that would be in juvenile court if you're charged as a juvenile. But if you're charged as an adult, that's going to be in a district court, criminal court. And the judge can then choose to allow you to be detained in an adult jail or a juvenile facility. Now, the timeframes are different in terms of how speedy the trial has to be. So if you're being tried as a juvenile, there are shorter time frames. You can only be held for 30 days before trial. There can be waivers to that, but if you're in adult court, there's a much longer time. So you're going to be in adult jail a lot longer. They have 180 days for that until they have to go to trial. Now, in both situations, you can be moved up or down. So in juvenile courts, depending on the offense, it's possible that the prosecutor can do a petition to waive you up to adult court. In this case, the prosecutor has the burden of proof and has to prove it's more likely than not that the young person is unfit for juvenile rehabilitative measures. If you're in adult court, that's switched. You, as the child, and your attorney have to request the transfer back down to juvenile court, and you have the burden of proof to show that it's more likely than not that it would be in the best interests of the child or society to be transferred. To prepare for the waiver hearing, it basically looks the same. DJS is going to do a full psych and evaluation and take into account the young person's family and school life, etc. In both cases, that's going to take about 2 to 3 months, but where you are during that, of course, is very different. So if you're in juvenile detention, they have a school in the detention facility, and you'll get some type of evidence-based rehabilitative programming. But if you're in an adult jail, often you're in solitary confinement for your own protection. They're not always. And there's no school there. I'm probably not getting any education at all, maybe some worksheets. Again, this shows that you can be transferred, either way. And this is just going over again those time frames. So we arrive at the trial. If we're in juvenile court, there can be some delays, but there are limits on how long those delays can be. And then after sentencing, you can either be released on probation or sent back to juvenile detention, awaiting placement in a juvenile program. And the judge has discretion to recommend what level placement you're sent to. If you're in adult court and found guilty, at sentencing, you'll receive either a prison sentence or probation. Now, when you're in the juvenile court, you'll be assigned a case manager once you're sentenced, and they'll be in contact with your school and your family. They'll kind of collaborate to keep you on track in your educational program in the facility. You may get referrals to other types of therapy and programming. If you are in the adult system, you'll be assigned an adult probation officer, and they will be solely focused on the young person staying in compliance with their probation terms. There will be no rehabilitative services or behavior modification programs. If you need treatment, you'll have to secure that on your own. So again, if you're sentenced as a juvenile, you're placed in an appropriate DJS facility. If you're sentenced as an adult, you're going to go to the Department of Corrections Diagnostic and Classification Center, and from there either to DOC's Patuxent Youth Program or to any other adult prison. So when you're sentenced as a juvenile, again, if you're in a DJS facility, the staff are trained in trauma-informed care. You will receive an individual treatment service plan. If you're in an adult facility, even if you're at the Patuxent Youth Program, individual therapy is not available. There may be group therapy. At this time, there are no trauma-informed practices used. There's no school like there would be in a juvenile facility, only GED classes, no high school diploma, no vocational programs. If you're in a juvenile facility, you will complete your program and be released and be provided with some type of wraparound services and a DJS case manager. If you're in an adult jail, when you're finished with your sentence, you may be on parole. You may get some support if you go to a halfway house, but no continuing services will be provided. And this is just a chart, showing what we went over and kind of the pretty stark differences between a young person in the juvenile as opposed to the adult system. I want to discuss an incident that happened this past fall that many of you might have heard about. There were racially charged comments made by white students during a football game between Bethesda Chevy Chase and Walter Johnson high schools. And then following the game, a 16-year-old disabled Black boy was involved in a fight, and he was arrested and charged as an adult. This was because he was carrying a BB gun, though he had never used that gun. The 15-year-olds in the fight were put into the juvenile system. So, even when a child makes a mistake or does something wrong, he's still a child that needs to be cared for. And the disabled teen in this case was treated by the police and prosecutors and the other state actors really as an adult threat to the well-being of the other children. So this criminalization of this adolescent boy really did not make anyone safer. It didn't address the violence and really didn't demonstrate respect for either the children who acted violently or the children who were harmed. It was going well for a while, and there we go. All right, so the YES Act changes the way teens are charged with serious felonies as they enter the justice system. So it establishes that all youth under the age of 18 will begin their case in juvenile court. It doesn't mean that they can't be transferred. So the system we saw in place for moving a child from juvenile court to adult court will still remain in place. So prosecutors can still seek to move a teenager's case to adult court, and the judge then will determine the appropriate venue. The bill sponsors in the past for the YES Act have been Senator Jill Carter, who's a Democrat in Baltimore, and Delegate Charlotte Crutchfield, who's a Democrat here in Montgomery County. And the committees it goes to are the Senate Judicial Proceedings Committee, which is chaired by Senator Smith, who's in my district, District 20, and the House Judiciary Committee, which is chaired by Delegate Clippinger, who is a delegate from Baltimore. Our analysis is that this is a winnable issue, but we really need very strong community organizing and a larger coalition. This bill has been introduced a lot, so this will be the 14th year that it's introduced. So there is entrenched opposition, but also many learnings from our past sessions. And our partners include members of the Maryland Youth Justice Coalition, the Office of the Public Defender, Bridge Maryland, the ACLU, the Sentencing Project, and many others. So we do have a large coalition. But I will say the climate is not good. Especially in the Baltimore area, Fox News and conservative radio have really been hammering for months and months that we have a juvenile crime crisis. That is not borne out by the data, but they've been making their case and really had a big impact on the public and on legislators. So we're going to be playing a lot of defense. One of the bills they're attacking is a bill JUFJ prioritized in 2022, which passed, and that had to do with protections for children being interrogated. That's under attack, so we'll be defending that. There were other reforms in 2022 that, for example, set a minimum age at which young people can be tried in the juvenile court. That's also going to be under attack. So at JUFJ, we're working on protecting those past wins as well as trying to move forward with this progressive legislation. We have a working group that I really encourage you to join. We meet every couple of weeks. So the next meeting is this Monday, December 18th at 7:30. And there's a link there, and maybe Anita or Carol or somebody could paste that link into the chat if you'd like to attend. And we work on the YES Act and organizing for that, as well as I said, protecting these wins from the past years. And to learn more and get involved, there's Facebook, Instagram, Twitter handles for both the Maryland Youth Justice Coalition and for JUFJ. And I will stop screen sharing now and take any questions. So thank you for bearing with some of my computer difficulties. And I'll see if there's any questions in the chat. Sorry, I didn't see the request to speak louder. Hopefully you guys could hear me. And
Miriam has a question.
Yeah, go ahead.
Hi, Melissa. I know that, last year you got this thing passed about, the kids having a right to have a parent or a lawyer present on initial interrogation. Are there any other procedural protections available in adult court that are unavailable in juvenile court? I'm thinking particularly of Miranda warnings, jury trial, right to counsel at trial.
Yeah, so in terms of interrogations, that would apply whether you're being tried in juvenile or adult court. So the law pertaining to kids is for any minor under the age of 18. I don't really remember about the jury trial. My husband's shaking his head no. He also does juvenile work. So no, there's no jury trials for kids in juvenile court in Maryland.
The reason I bring this up is that I'm just wondering, is there any way you could import some of these procedural protections? Are you doing anything to import further procedural protections in juvenile court? And the reason I ask is that in my own experience, one of the more therapeutic possibilities of a courtroom for a kid is a sense of fairness. I know the whole point of juvenile court is to be very nurturing and to constantly, we're talking about what's wrong with this kid. And I've met a lot of people who are so busy with what's wrong with this kid and how can we help him. And they never bother to find out that he do what he is accused of doing. And the procedural protections do address that. So I just wondered if anything is being done so that the advantage of juvenile court isn't somehow vitiated by his having fewer procedural protections.
So it sounds like maybe I'm not sure, Mim, but are you saying that maybe there can be net widening if a child's in juvenile court, that they may may end up staying there longer because they want to get them services and that type of thing? Is that what you were getting at?
No, just
Yeah.
that so much emphasis is placed in juvenile court, quite rightly, on the psychological profile of the child. And I don't know how much attention is paid to ascertaining whether the child actually did what he or she is accused of doing. And
Right.
that those protections that are afforded to adults have an emotional fact. They play a role in one's emotions too, as far as whether you're being treated fairly. Let me give you an example. I was dealing with this is years ago, but I was talking with a colleague about juvenile court, and she said, "Oh, all children should be." If the kid was a kid was complained about, he'd been babysitting a younger child, and he was accused of sexually not molesting, but bothering, let's say, the younger child.
Mhm.
Oh, he should immediately be analyzed, tested, this and that. And I said, well, did he do it? Did it in fact happen? Oh, doesn't matter, she said. We're nurture. Every child needs nurturing. So, but did he do it? Doesn't it matter to you whether he did it? No, it didn't matter. So I realize that's a gross exaggeration
Right.
of how people actually act. But I always have had that little fear that ascertaining the facts gets to
Yeah.
be less important in juvenile court. And for some people, there's an actual advantage to being waived immediately into adult court.
Yeah, I hear what you're saying. I think there's a few things. First of all, that was kind of an older, like maybe two decades ago or something. There was more of a sense of juvenile court being very helpful, and it didn't matter so much, like you're saying, what happened. We just want to get them these services and help them out. I think that view of juvenile court has changed because as much as it is better than adult court, it's still serious. It still can stain a young person's record and trajectory. It still can be a very harsh, unpleasant setting. So there have been more and more procedural protections for juvenile court. That are pretty similar to adult court, other than the jury trial right. A lot of the other protections also now apply to juvenile court. Over the years, they've been added. Um, and, you know, with any court you're in, it depends on the attorney you have, but hopefully, and there are very good public defenders in Maryland. They have a very good system. And so I know the public defenders take it very seriously, and um, I don't think they would take that stance. If there was a question about whether this child actually committed the offense, and it should go by the child's expressed interests. So if the child is saying, I didn't do this, I don't want to take this plea, I want to go to court, that is what the attorney should do. And there will be a trial, even if it's a bench trial, with all the evidence presented and so forth.
Is it a two-stage
It may-
proceeding?
I'm sorry.
Is it a two-stage proceeding? A fact finding and then a dispositional hearing?
Yes.
I-
Actually, I don't know if they do the disposition immediately following the trial or not. I'm not sure how they work that.
What's interesting is that of these young people who were sent to adult court on these 33 charges, approximately 80% of those young people do not end up actually being tried in adult court. What happens is for half of them, the charges are dismissed. There's insufficient evidence. So here's this young person who's been sitting there, on this, rather significant charge and sent to adult court, and all this stuff happens, and then the charge is dismissed. The remainder of those 80% of the kids are actually sent by the adult judge back to juvenile court. So this is not just harmful to the child, it is churning the system. It is, to me, it's a make-work project for the state's attorney's office. Because you have to have these attorneys doing all of these things. Now, if you started the child in juvenile court, you would have those kids staying in juvenile court and or their charges being dismissed. And the 20% that needed to go to adult court probably would be sent up to adult court for their trial. So it just ultimately makes no sense, and it's certainly not in terms of keeping society safer. Mark has raised his hand.
Great, thank you, Anita. Yeah, go ahead, Mark.
Actually, it's Marilyn.
Sorry, Marilyn has raised her hand.
That's
So-
fine.
I might have missed some of what you said at the beginning, but if a kid has an emotional illness or mental illness or diagnosis, do they get treatment? Do they get a case manager? Do they get anything special? Or that's my question, basically.
Do you mean, Marilyn, if they're being tried as an adult?
Do they just get support no matter how they're tried? Whether they're in juvenile or adult? If they're juvenile, do they get
Right. I mean, it's
wraparound service from the mental health?
much more likely in the juvenile system. I mean, it's not a great, I'm not saying the juvenile's not like fantastic, but it is better than the adult system. They do have more resources and they are set up and geared to deal with children. So yes, they should get a psych evaluation in a juvenile setting. In the adult setting, I mean, if a person presents with a mental health issue, I would hope they'd get some type of evaluation, but it's much less likely because they're overburdened and they're just not really set up to, especially to deal with children. So, and some of the jails are really just atrocious. So I know both the jails in Charles County and in Baltimore have asked the Department of Justice to look into their facilities because the conditions are so abhorrent. So the chance that they're getting any kind of psych evaluations or treatment is pretty minimal, I would say.
Thanks.
Betsy.
Thank you. This is great information, and I would like to be involved. I am less involved in DC Public Defender Service, where I worked for some years. Where's Vinnie Schiraldi on this, who is the new head of, as you know, the new head of Juvenile Services for Maryland? And what, are the state's attorney, is the state's attorney saying the typical, it's an adult offense, therefore he needs to be treated, or she, as an adult? Is there anything new that they're saying?
Yeah, the prosecutors are very protective of their turf and they are staunchly opposed to this bill. They especially don't like the fact that their burden of proof shifts. So if all the kids start in juvenile court, then they have the burden to show they have to be waived up. So that really angers them. So they've been fighting hard against it, which is why it's been, we're going on year 14. But Vinnie Schiraldi, so for those of you who don't know, he's the new director of the Department of Juvenile Services. He's a very strong juvenile advocate. He comes out of an advocacy background, though he's gone in and out of, he ran DC's Department of Juvenile Services at one point, and New York's. He is strongly in favor of the YES Act, but he works for Governor Moore, and Governor Moore has not decided what his position is going to be. So we'll see, what he's allowed to say or not do, or say or do in the legislative session. But personally, and he has said that he is in favor of it, and he feels that the Department of Juvenile Services could handle the additional young people. But I will say Vinny just took over, I think in the fall. So he hasn't been there very long, and he
Right.
was left with a bit of a mess. And so the impression the legislators have of the Department of Juvenile Services is a very poor one, and they feel that they are not up to the task. So he has a lot to do to overcome that.
Thanks.
Can I ask a quick question? What has been the role of church leaders and those kinds of folks around this?
So on the Maryland Youth Justice Coalition, Reverend Tillman is a very involved, very member of that coalition, and he's worked on this bill for a long time. I know that he also will contact other faith leaders, and he tries to do that type of outreach. So I'm not sure, that's the extent of my knowledge of, the outreach to faith leaders, but that is a good question, and it would be good to bring in more of them.
Because many of the, well, I don't know of any of the Black churches who don't have some sort of a youth focus, some, so one, I mean, I think it's important that word gets out, like what's happening here, and not just to ask for support for the act, but to inform these folks that you want to, the best way not to have to deal with this is to stay out of the system. And so, I mean, I think some of this needs to be, disseminated if it's not already, to talk about like pretty simple stuff. If you get caught up in this, and I know we're dealing with young kids, and I know that they act impulsively, but there's some, particularly in these churches, there's a lot of peer pressure to, not get involved in this kind of stuff. So, I think this is an opportunity for education, before a kid gets swept up.
Yeah, I agree. That's a very good point.
Melissa, I know that the list of 33 offenses has grown. And I know over the years, there's been some attempt to at least, most of the states, if they have this, it'll be like the 2 worst offenses that auto charge. But we have this massive list. And, is there any thought of at least addressing that?
So the advocates have not wanted to compromise in that way, because if you just start knocking off, a couple here and there, it's just not going to do much. There was a compromise suggested way at the end of last session that was very good, where it basically would remove everything from auto charging except for murder and like first-degree rape. It was something like that, except for like, some like the 2 most serious offenses. But it was so late in the session, and actually the Senate sponsor, Senator Carter, wasn't in favor of it for some reason. It was kind of a mess, as things get at the end of the session. So unfortunately, it didn't go anywhere. But that type of a compromise, yes, but not just knocking off a few of them. That's just not been something the advocates, and especially the impacted youth and families, have not wanted to do that. So I would say, though, not like, and I know somebody asked what the offenses were, they're all serious offenses. So it's not, the issue is not that, for the most part, that they're like silly little offenses on the list. It's that no matter what the offenses are, the child should start in juvenile court and a judge should review the whole situation. What they're charged with, what their psychological profile is, what their actual age is, what their level of maturity, should view the whole child and be the one as a neutral arbiter to make that decision, instead of a prosecutor who is in essence making the decision by making the charge and who is influenced by, politics and is just not the right party to be making that determination. So I see in the chat, Mark Sugarman asked if the juvenile case is dismissed from adult court, is everything expunged automatically, or does it remain on the juvenile's record? I think it remains on their record, but I'm not an expert in the expungement law. So it could be that there are certain offenses that can be expunged, whether you're a juvenile or an adult after a certain period of time. I'm just not, that familiar with that area of the law.
But I think I think that the issue is if the judge in adult court hears it and the charges are dismissed, so there's no finding of guilt,
Okay.
then it should just go away. There shouldn't be something on that child's record that says, oh, he was taken to court for this.
Yeah, I don't know though if that, the arrest could very well, for example, remain on their record. I think something would probably have to be actively.
Yeah, you may have to ask to have the record expunged. There may be a process. I don't think it's automatically expunged. I mean, I'm from New York, and my experience is that you can apply to have a record expunged, but it's not automatic.
Yeah, that would be my sense.
And your attorney has to then say, we wish to apply for an expungement.
Yeah. It's not going to show up as a conviction because you're not convicted, but.
No, but
it will show up that you were arrested.
Exactly.
Charged, and so forth. Yeah. And Mark Sugarman says juvenile records are sealed and would not count in adult court down the line or in public inquiries. Okay. I'm not sure if I've missed any questions in the chat, but if anyone else has any last questions before we finish up, I'm happy to entertain them, or Anita can. Okay. Well, I appreciate all of your time, and I hope you'll get involved with the working group if you're interested. We could use more help and support, and you will be hearing more about this as session starts in mid-January, and as we start, gearing up for that. So.
Thank you all very much for coming. Don't hesitate to reach out if you have any more questions. I'm sorry, Betsy, I didn't mean to cut you off.
No, I'm sorry. Should we, if we're interested, should we just try to get on the Monday meeting, or, the Zoom, is that how and is that the same Zoom every?
I don't know if it's the same Zoom, but if you sign up for Monday's meeting, you'll automatically be added to the list of folks and you'll get a notice about every meeting.
How do we sign up for the meeting? I didn't see that.
I put it in the chat. I'll put it in again.
Oh, I'm sorry. I'll look for it.
No, I'll put it back right away.
And I'll put my email in the chat also. So if there's any questions or anyone can't find, how to get involved, I'm happy to help you out. So feel free to
just click on the link. It'll take you right to the sign up page.
Great. Thank you.
Mm-hmm.
Right. Any other questions or comments? Okay, well, thank you all very much for coming. We look forward to